ordered by the court. Before filing for the attachment, however, the plaintiff must post a bond to cover any loss suffered by the property owner in case no judgment is awarded. This is the only lien that absolutely prevents a sale or any other conveyance of a property. It is an involuntary specific lien. General liens. A general lien is one that encumbers all real and personal property owned by a debtor, including properties owned before the lien was recorded or properties acquired after. To be effective, the lien must be recorded in all counties where the debtor owns property. General liens result from judgments, federal or state income taxes, and a decedent's debt. They are all involuntary. Judgment lien arises out of a lawsuit when one person, the plaintiff, sues another person, the defendant, for damages, and the plaintiff wins the suit. The court awards a judgment in a specific dollar amount to establish the indebtedness. The judgment when dollar amount to establish the indebtedness. The judgment, when recorded in the county records, becomes a general lien against any real or personal property owed by the defendant in that county. A lease pending may have been filed to alert title searchers that a suit is pending. It is also possible that an attachment lien has been granted to prevent the defendant from disposing of a property that might be included in the final decree. Once the judgment is rendered, if the debtor does not pay the amount due, the creditor may ask the court for a writ of execution, authorizing the sheriff to seize and sell enough property to pay the debt and costs of the sale. When the debt is satisfied, the debtor should receive and record a satisfaction piece of evidence. Recording this will then clear the title. Federal and state income taxes. Any unpaid federal or state income taxes become general liens against the taxpayer's real or personal property. The lien will be filed against the taxpayer in the county where the taxpayer resides without court intervention. Federal and state inheritance taxes. Property owned by a decedent is subject to federal estate taxes. Federal estate taxes after certain exemptions are allowed. If this tax is not paid, all property in the estate is encumbered by a general lien. Some states also assess inheritance taxes, and the same rule applies. Decedent debts. When someone dies, existing liens on the decedent's property must be satisfied before the property passes to the heirs. Outstanding debts that cannot be paid out of the decedent personal property creates a lien against real property, and the real property can be sold to satisfy the remaining debt. Property encumbrances which affect the use of the property. The use of privately owned real estate may be limited or restricted by the rights of other people. Private encumbrances which affect the use of property may be easement, deed restriction, or encroachments. Easements. An easement is a non-possessory, intangible right one person has to use another person's land in a specified manner and for a specified purpose. The holder of the easement does not own or possess the land, but has only an interest, a right of use. Because an easement is an actual interest in the land, the statute of frauds applies, and an easement which is freely given must be in writing. The easement is irrevocable and an encumbrance on the grantor of that right. Easements are either appurtenant or engross. Easement and appurtenant. To create an appurtenant easement, there must be two separate properties, usually, but not necessarily, adjacent to one another. They must have different owners. The owner granting the easement and therefore burdened by it is known as a servient estate. The owner that benefit from receiving this right is the dominant estate. The appurtenant easement is said to run with the land. In other words, it is not just a contract between two owners, but a relationship between two parcels of land. When ownership of either parcel is transferred, the easement automatically goes with it, whether or not mentioned in the deed. Examples of this type of easement including common driveways, a right to use another person's land for ingress or egress, a right to use water from another landowner's well, or a party wall. A party wall, often found both in commercial buildings and in townhouses, is a wall that straddles the boundary line between two adjoining property and is a part of the improvement on both lots. Typically, each owner owns the half of the wall that is on his or her side of the line and has an easement right to the other half. Neither can tear the party wall down. An appurtenant easement can also be created to benefit the dominant property by requiring the servient landowner to avoid doing certain things on the property. For example, a view easement will preserve a dominant owner's panoramic view by prohibiting the servient landowner from building improvements or fences above a certain height on certain part of the lot. Easements are generally both bought and paid for because they have value. The existence of the easement increases the value of the dominant parcel and also decreases the value of the servient parcel. An appraisal can be used to estimate the values involved. Easements in gross. An easement in gross involves only one tract of land, the servient estate. It benefits a person rather than another parcel of land. It is a personal right to use the land of another and does not necessarily run with the land. When an easement is granted to an individual, it is personal easement in gross. A personal easement in gross is irrevocable during the lifetime of the person to whom the easement was granted. It is not transferable and will terminate with the death of the person to whom the easement is granted or upon the transfer of title to the property. An example of this is the right to use someone's lake for fishing. Commercial easement in gross, such as utility easement, railroad, right-of-way, and right to erect billboards, are more valuable interests and are freely transferable and inheritable. Creation of easements. Easements may be created by a deed in which an owner grants a specific right for another person to use the grantor's land. Reservation. An owner might sell some land but reserve an easement in the deed. For example, the owner of 100 acres sells 75 acres but reserve the right to use a driveway to get to the remaining 25 acres. Agreement. The parties may express their intent to create an easement in a written contract. For instance, certain water right or a common driveway might be created by agreement. Necessity. An easement arises out of necessity when an owner sells land in such a way that deprives the buyer of reasonable access. No written document is required. The buyer has a right of ingress and egress to the landlocked property. Prescription. An easement by prescription is acquired through continuous use of another person's property for a period of time prescribed by state law, usually 10 to 20 years. The use must be open, visible, and notorious, and without permission from the owner. For example, a person using a corner of a neighbor's lot as a shortcut to the highway for the statutory period of time might be able to acquire an easement by prescription. Implication. An implied easement is one created by operation of law. For example, if mineral rights are sold without granting the purchaser the right to enter the property and extract the substances, the law would assume an implied easement of reasonable access for the purpose of extraction. Condemnation. Under this right of eminent domain, the government can acquire an easement over privately owned land for a public purpose through condemnation. The right can also be delegated to quasi-public corporations such as utility companies and railroads. Since easements do have value, the landowner must be paid just compensation. Termination of easements. An easement can be terminated in any one of the following ways. Release. An easement can be terminated by a written release from the owner of the dominant estate to the owner of